Hi, I'm Sam Simpson. I'm CEO of Founder Catalyst. What I want to talk to you today is about all of the legal things that I wish I knew as an angel investor when I started investing. And we are going to cover things like the standard terms within a funding round, what paperwork you should use to make sure you're SEIS, EIS compatible, and the very basics of investing in a startup. Let's start with the basics. Why do you need legal paperwork when you make an investment at all? Basically, the answer is these are rights and protections that you are obtaining into the startup. There is no fundamental legal basis why you need any documentation at all. So for example, if you're investing in a family and friends round, it's fairly standard not to have any documentation at all. You throw your money in, you get a share certificate, and hopefully you get your SEIS and EIS forms if you're eligible, and that's it. So legally, you don't need anything for it to be compliant. However, if you're investing in people you don't know, so it's not a family and friends round, I, and certainly you should as well, would want protection, and that's offered by a set of legal documentation. Within the UK, there are 3 standard ways of investing, and I'm going to tell you first the documents you shouldn't be using in the UK. So if you're investing in an American company, for example, you may use something like a safe note or a convertible loan note or an option and warrant. Those are all confusing. I'm not going to mention them again because they're not compatible with the SEIS and EIS scheme. I've never once invested using them, and I never see them in the wild. And that's because to be compatible with SEIS and EIS, you need to invest in one of 3 ways. Those 3 ways are, firstly, an advanced subscription agreement, secondly, a price round, and thirdly, under this newfangled agile investment, which I absolutely love. It is the most elegant way of investing in a startup to my mind. First, let's dive into an advanced subscription agreement. Within the UK, this is called a few things. It's also called an ASA as an abbreviation. Personally, as an investor, I really dislike ASAs for lots and lots of reasons. I won't go into detail here because I've only got 10 minutes, but they give very limited rights and protections to investors from day one. They are very brittle in respect of your SEIS and EIS tax relief as well. There's more details, much more details on why I dislike ASAs in the comments below. You do need to be aware of them though, because they are quite prevalent in the UK. As I say, they're one of the 3 ways you can invest. And what they allow founders to do is take money ahead of a funding round. They can take money in dribs and drabs, and they allow the founder to defer the valuation further down the line. So they're great from a founder's point of view, which is why founders are jumping at them. From an investor point of view, I absolutely don't love them. I won't say any more on ASAs other than they are prevalent and they are not investor friendly particularly. Let's move on to price rounds, and this is the traditional way of doing a funding round. It's called a price round or a big bang, where a founder is responsible if they're raising, say, £500,000. Traditionally, they would get 10 investors for 50k, and they would try and herd the cats and get all those investors in one place. And there's a big signing ceremony where all 10 investors sign all the documentation, as well as any existing shareholders and founders and investors. So everybody signs the documentation in one place. The problem with a price round is that they're quite brittle as well, in as much as you've got to get 10 people plus all of the existing stakeholders in one place at one time. And if one person walks away, then the round can collapse. So from a founder's point of view, it's really risky. So they are looking for a more agile type of investment. Which brings me nicely on to the third method here, which is agile investment, which for me as an investor is the best of both worlds. It brings much more agility to the investment process, where a founder doesn't need to get all 10 investors with 50k each in one place at one time. They can take on the first, 3 investors, the first 150k, and then raise the remaining £350,000 over the next 6 months or whatever. So it's removing all of that big bang, big pressure from the founder. It allows them to raise over more time, which means they can take the first £150,000 on and they can start deploying it and spending it, and therefore improving the startup over time. The documentation you get in each 3 cases are different. So under an ASA, you'll receive your share certificate when your ASA converts into equity. Under the other 2 types of investment, you get a share certificate almost immediately. So as soon as you sign the documentation, transfer the cash, you'll get a share certificate immediately. The other benefit to not using an ASA is it allows the founder to start that SEIS compliance and certificate process, which allows you to claim your tax relief. They can start that from the second you put your money in. Whereas under an ASA, typically you wait 6 months and then they start the process to allow you to claim your tax back. The documents under an ASA or an agile round are ridiculously straightforward. It's one document, either an ASA or an adherence agreement. You sign that and you're done, at least for a while with an ASA. So let's walk through what documentation you should expect as an investor under a price round. There are a number of documents, some of which you should probably care. more about than others. But let's walk through all of them just so you are fully aware. The main two documents within a price round are a shareholders agreement, or a subscription and shareholders agreement, or an investment agreement. It may be called one of those things. But ultimately, it's a legally binding contract between the founders, any existing shareholders, the company, and you as an investor. This, like any legal contract, defines your relationship between all of those parties. It is a fundamentally important document in this process, and you should only be transferring money once you sign one of those documents. The other big document is something called the Articles of Association. These you can see for every company on Companies House, and these define the rules around a couple of key sets of actions within a company. So how does a company manage its shareholding? So issuing new shares, removing shares, selling shares, all of those kind of things, they are documented within the Articles of Association. And also, how does it manage its board? How does it allocate directors, remove directors, investor directors, whatever it happens to be? Those things are all documented within those Articles of Association. Those documents together are about 90 to 100 pages, so they're really, really heavy reading. The other documents, thankfully, are much smaller. So what other documents would I expect to see supporting a funding round? Two critical documents for me are the Founder Service Agreement and the IP assignment. So firstly, the Founder Service Agreement is effectively an employment document, and there should be one for every founder within a business. The reason why these are important, they will typically dictate and stipulate things like restrictive covenants, things the founder can and can't do, whether they're full-time, how much they'll be paid, and things like that. So it's really important to get that level of detail and check that that agrees with your understanding. The last thing you want to do is invest £50,000 and find out that the founder's salary is £50,000 a year. So all of your investment goes down the drain instantly on salary. That would be a bad thing. The other really, really important document for me is the IP assignment. The IP assignment ensures that all of the intellectual property that is required to run the business is owned by the business rather than the founders. And there's a really funny anecdote which for me proves exactly why these are required. So everybody hopefully has heard of Adam Neumann, the ex-CEO of WeWork. So he took a multi-billion pound investment from SoftBank. He took billions, literally billions. The very next day, he wrote in his personal capacity to WeWork and claimed that he owned the IP, the trade name to the word we in WeWork. And WeWork had to pay him, I think it was $5 million, though don't quote me, in order for them to continue using the word in WeWork, which is genuinely ridiculous. So that would have been mitigated if only SoftBank had insisted on seeing an IP assignment in that case. There are a few other supporting documents. I'll mention them for completeness, but these are probably less important to cover at this stage. Firstly, there's a disclosure letter. This is related to a process called warranty and disclosures. I won't go into detail here because it's quite convoluted, and it's also quite challenging to understand if you've never been through the process, though there's a link in the comments below which will allow you to understand much more on this process. There are also a couple of documents which authorize the mechanics of issuing the shares and adopting the new Articles of Association. So there should be shareholder resolutions and board minutes to authorize this funding round from both a shareholder point of view, but also from a board point of view. From an investor's point of view, the whole purpose of having this documentation is ensuring that you have rights and protections that are legally bound within documentation. So these are very, very much in your interest. What are these legal terms that I've mentioned? So there are hundreds, and we're not going to cover them all because we don't have time, but I'll just name a few of the very, very standard terms and then just call out a couple of additional terms that I personally always ask for because I've been stung when I don't ask for them. So you should have a set of standard protections within either the shareholder agreement or articles, things like preemption rights, which is the ability to maintain your shareholding percentage even though the company does additional funding rounds. So it's the right, but not obligation, to acquire more shares if the company does another funding round. There's also a standard right called tag along, which means that if the company sells the majority of their shares, you also attach yourself to that transaction, so you benefit at the same time as everybody else investing. Otherwise, you could be left pretty lonely on the cap table with somebody else who owns the company that you don't actually want to work with for whatever reason. So there are really, really standard terms like those that will be present in absolutely every funding round. And if they don't exist, then you've got a bigger problem. Some terms that I always look for that aren't always offered by founders, but I think as an investor are really important to me. The first one is information rights. So this is an obligation on the company and founders to give you regular updates. It sounds daft you should have to ask for this, right? A founder should be updating you every quarter-ish in order to tell you what's went well, what's not gone quite so well, any metrics that would be useful you understanding, and maybe any ask for help, if they need an introduction to a specific supplier or customer, whatever it happens to be. But in my experience, I've got 32 investments, only one of those routinely gives me updates every quarter. It's a bit crazy. So the way you can ensure that you are updated is to ask for something called information rights. And like I say, this is an obligation for the founders to update you on a quarterly basis, say, it doesn't have to be huge, just a one-pager telling you how the business is doing. So I always ask for that because otherwise you just don't get it. The other thing I ask for, and this one is much more contentious, is around investor consent. And the reason I ask for this, I've been bitten in the past where founders have done things that I wouldn't want them to do because I've got no way of protecting myself and stopping them from doing so. So I always ask for something called investor consent. And this is basically where if the company wants to do anything particularly interesting, like change its name, change accountants, change what they do as a trade, close down maybe, or whatever it happens to be, they have to ask the existing investors to consent to that transaction. And obviously, if it's something that makes sense, if it's something that will benefit you as a shareholder, you will consent without blinking. But it just protects those instances where a founder wants to do something that maybe you're not quite as bought into. So that's it. Those are the things I absolutely look for every time. In the comments, again, we've got lots more details of lots of other terms you will see. We don't have time to cover that in this video, unfortunately. Thanks again for watching this video. Hopefully it's been useful to bring to life some of the things you need to look at when it comes to legal documentation as an investor. If I could give myself one tip 6 years ago, it would be to join an angel syndicate, a private equity club or angel network. There are about 130 in the UK. There's probably one somewhere near you, and there's probably one maybe that specialises in a sector that really resonates with you. And the reason I would join that, as we've kind of brought to life today, there are loads and loads of things you need to know in order to do a funding round. There are lots of ways of doing it. There are lots of things to look out for. And actually, there are new and novel ways I hear of every single day of being stung as an investor. That's not to dissuade you from investing. It's just to understand that it's really hard to understand the best practice and how to best mitigate your risk when you're investing. I would join one of those private equity club, angel networks or syndicates, whatever you want to call them, because there will be lots of people in that group who have made lots of investments. They've made lots of mistakes. They will understand the things that you really should and shouldn't do and allow you to focus on. So I'll post a link in the comments as well on the interactive map of every single angel club in the UK, and turn up for a taster session. They won't charge you. They'll welcome you with open arms and you can pick somebody's brain. That would be my tip for the day.